Good afternoon. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and welcome to our webinar today, Estate Planning and Elder Law Essentials. We offer this presentation many times throughout the year, and we're pleased to be with you today. How this will work today, you are on mute. However, if you have a question, please note it in the box on the right-hand portion of your screen, and I'll find an appropriate time during the presentation to pose the question to Steve. And we'll also have plenty of time for questions at the end. You receive the presentation ahead of time for your convenience to take notes if you wish. You also received an evaluation and consultation form in the same email. So please take a few minutes at the end and email it back to me. You can fill it out through Microsoft Word and tab through it very easily and save it and send it back to me at jeff@elvilleassociates.com. That's JEFF at elvilleassociates.com. And this is your opportunity to offer us feedback about the presentation and also request a time for a free consultation with Steve to discuss your family's planning needs. And we'd like to be a resource for you. And there's nobody better to guide you through the planning process than Steve. A little bit about our firm, if you're not familiar with us. We were founded in 2010 by Principal and Lead Attorney Stephen Elville, and we have a number of different practice areas here at the firm, including estate planning. We also focus in special needs planning, elder law and elder care planning, estate and trust administration, asset protection. We have a litigation department that focuses on guardianship and other matters of that nature, as well as tax planning. We have 7 attorneys, 5 different locations, and 12 staff members as well. Our mission is to provide practical solutions to our clients' needs through counseling, education, and the use of superior legal technical knowledge. And we focus a lot on education here at our firm, which I think you'll see today. And we do that through our planning process with our clients. We offer over 100 educational workshops throughout the year in many different venues and also through webinars as well. And we also have an accredited client care program that many of our clients take advantage of that takes education to an even higher level. I also have the pleasure of introducing today's speaker, who many of you know, Mr. Stephen Elville, Principal Attorney and President of Elville and Associates. His work is centered in elder law, special needs planning, and estate planning, with a special emphasis in the areas of tax planning and asset protection. He's a member of the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. And he works to bring peace of mind to clients by creating solutions to their needs through counseling, education, and the use of superior legal technical knowledge. He was also last year's chair of the Elder Law and Disability Rights Section Council of the Maryland Bar. And he's a seasoned speaker and presents at about 75 workshops and webinars, conferences, and continuing education events each year. He was also named to the Maryland Super Lawyers list for a 5th time this year. So congratulations to Steve. And without further ado, I'll turn it over to him.
Hello, and thank you, Jeff, and good afternoon to everyone. I just want to say thank you for attending today's webinar, which is about estate planning and elder law essentials. It's my privilege to be here with you, and I want to thank Jeff for organizing this webinar, and he'll be our moderator today. And we're going to take questions throughout this webinar. Normally at our estate planning essentials workshops, we take pride in taking a lot of questions at the beginning of the workshop, because we know many of you who are in attendance may have questions that have been on your mind for many years or months, and you might want to get answers to those questions as part of your reason for attending. And we still want to make sure that we take all the questions today that you may have, and if possible, we will do that during the course of the webinar. And afterwards, we would like to be a resource to you as well. And you may email us those questions to me, steve@elvilleassociates.com, or to jeff@elvilleassociates.com, and we will do our best to give you some information about the nature of your question. So I hope that you are safe and well today. I know this is an extremely challenging time that we continue to live through. Thanks to our wonderful governor, who I think is doing everything he possibly can to keep us all safe here in Maryland. We are continuing to operate on a modified basis. to continue all of our normal estates and trusts and estate planning, special needs planning, and elder law services going and providing those services on a continuing basis. And we are taking all necessary precautions and protocols for social distancing and how we execute documents, which we are now allowed to do by remote notarization, remote witnessing, and so forth, thanks to our governor. So if you have a need today with regard to your estate planning, there are ways to make sure that we can help you do that, either in a in-person meeting through way of a signing in your vehicle in a parking lot, believe it or not, or where it's absolutely essential, we can meet people in our office, or we can do things remotely. So we are continuing to provide services in the best and highest technology way that we can. You may have questions, so again, we're going to get started here shortly. And I want you to know that although a lot of material I'm going to present here is very involved, and it's going to get pretty much into the weeds, so to speak, quite into the weeds, I want to assure you that we will take time to answer questions as we go along, clarify things that might not be clear, and I promise that at the end of this workshop, you will probably know about 95% more than most people you know about estate planning and elder law. So just know that the presentation that Jeff will make sure that you have and you can print it out for your own use, that presentation can be a resource for you and a tool for you to refer to. So without further ado, I'm going to go ahead and get into our discussion. And remember, this is meant to be educational. At the end of this workshop, I would like to hear your feedback by way of an evaluation. And we also, of course, do a lot of document review if you have existing documents. And we also have no charge consultations to discuss estate planning with you if you have concerns. So with that said, let's get started. And I'm going to advance the slide. And we're going to get into this lengthy discussion about essentials in elder law and estate planning. So what is an estate plan and what is the process? We're going to cover that today. We're also going to cover what most people consider a rather surprising topic, which is why do estate plans fail and what can we do to avoid that? We're going to answer basic questions about wills versus trusts, and we want to understand probate and non-probate concepts. We're going to talk about elder law. What is it? Taxation and asset protection. What are these things? What do they mean to us in today's world? And we want to talk about how to get started in planning or how to get planning documents reviewed, whatever your situation may be, and how we can take the next steps. So let's get right into the material. How do we understand the estate planning process? Well, every single person has their own reason for planning. That's been my experience over these years. You're going to have your own goals and motivations about planning. In my experience, all planning is goal driven, no matter what kind of planning it is. I want you to be thinking about your particular reason for wanting to plan, or maybe you already did planning and you just need to evaluate what are my goals? What is my purpose for this planning? So you need to have a goal. We're going to talk about some of those, but we're also going to talk about why many plans do end up not working the way they're supposed to. And we could define that as a failed plan, depending on our own definition of it. But many plans become outdated. They don't work the way they're supposed to. We're going to talk about those reasons. So again, I want you to have a purpose of your planning. I want you to have a mindset of why am I doing this? What is it that I want to accomplish? And do I want a very simple plan? Do I want a more complex plan? And of course, we are big believers that you can't really make that decision until you're educated and you understand the scope of planning. But I want you to at least begin with a purpose. So for some of you, the purposes are going to be different for planning. Some people want to provide certainty. We want to get everything in concrete. I'll just say something about that very quickly. Our natural tendency as human beings, in my opinion, is when we are doing estate planning, we just think it's got to be perfect. It's got to be forever because it's going to be forever. And this is a common fallacy in planning. I want you to be planning for certainty, but I don't want you to think that your planning documents are forever. I want you to think of them as living documents that are going to be updated over a period of time. And although we're providing for certainty, there's going to be some flexibility there, hopefully, over the years for you to address changing situations. So don't get too locked into the idea of certainty, but that is something that many people have as a goal. We want to have smooth administration. We want the cost of administration to be smooth at the time of our passing, when our planning matures, so to speak. Some people want to provide for asset protection or do what we call marital protection for spouses, or we want to plan for divorce protection for children, grandchildren, and so forth. Many people are focused on taxes, and we want to understand the kinds of taxes we need to be concerned about. What are the different kinds, different types of taxation? And of course, I want you to think about your own definition of planning. So let's get into this issue of why do many estate plans fail, or maybe even most estate plans fail? Well, that gets back to an issue that's very fundamental. If I could just have you pause for just a minute. Most people do no planning at all. So when we are in a live discussion like this, I want to point that out. Statistics show that about 55% of all people, and as high as 62% of some people who are divorced, or maybe even as high as 75 to 80% of people who are age 44, 45, or younger, those folks have no planning. So the vast majority of people have no planning at all. And that won't be surprising to many of you. Then we have people who do planning, which are the minority of people. So let's say about 45% on average have an estate plan in this country. So the problem is that even for those people who do planning, the minority of people, those people traditionally are not encouraged, and this is where lawyers sometimes fall down. They are not encouraging clients to come in and maintain and update their planning. So what happens is about 20 years, or statistically about 19 years at a time, goes by between visits when someone actually does estate planning to the time that they actually follow up to review the estate planning. This is the beginning of what I would call plan failure, because the documents are not being updated with changes in the laws, with updates because of family changes or family situation changes over the years, tax changes in the laws. All of these kinds of things begin from the moment of inception of the documents, where there's no follow-up. We have a plan that may not work. The other reason for failure is in this first paragraph, as you may see here, that attorneys and clients tend to treat this as a one-time thing. That's why I was trying to get you to get out of the mindset of thinking about certainty. This is so certain that it's the one thing and it's the one thing I'm going to do forever. We don't want to have that mindset. We want it to be a fluid process where we have different phases of planning, which we're going to talk about next. And once we have more than just a transaction as our mindset, once we have more than just documents, this set of documents that I'm going to put into a safe deposit box, or I'm going to put this in my desk drawer or my closet at home. Once we have a mindset that planning is more than that, now we're on the right path towards planning that actually works. So I'm going to try to boil this down to two types of planning, and I'm being very fundamental here in my approach so that you can realize what I'm saying, or I can drive home these concepts. Traditional estate planning and non-traditional, or legacy planning, we call it. Let's look at the traditional planning, typically limited to one phase. This is what I was just describing to you. This is a transactional approach. I just need a set of documents, someone says, or an attorney says, here is a set of documents. And the documents are treated as the plan. The documents are treated as the living, breathing estate plan, but we know that's not true. And we know that in this particular type of planning, there's no education, there's no maintenance or updating of the documents. And the problem is that lawyers tend to lead this process of a transactional approach by not offering the type of maintenance and updating and education that clients need to really make sure their documents work. Now, of course, this is a two-way street. An attorney can't do this, or an attorney firm or estate planning firm can't do this on their own. So it is a two-way street. It is a partnership to get past this mindset. But I want you to first understand this particular mindset is what most people do, which is why most people's plans probably don't work the way they really should. So what we want to do is get away from this concept, and we want to have at least 3 steps, and I've tried to boil this down to spending lots of time implementing a plan, spending lots of time educating yourself, spending lots of time thinking about the issues. Jeff and I have talked about 2020 as being a time to think, and I think certainly with COVID-19, we certainly have a lot to think about and a lot of contemplation to do. But this is a different kind of thinking. This is the kind of planning where we want to be deliberate and mindful and take time to think about many issues. What are all the planning options? What are the flexibility measures? Who are going to be the fiduciaries? All of this is a discussion, and that discussion usually cannot happen really quickly. Now, with that said, there are people who are very concerned right now about what's happening in the world. We want to make sure that stopgap plans or that some kind of estate planning can be done on a quick basis if someone is ill, if someone is extremely worried about mortality rates here in this virus and what we're going through. So we understand that, and whether someone's traveling or whether someone's concerned about health, we want to implement plans very quickly. But overall, when we're not in a hurry, we want to take our time to educate. Phase 2 is maintenance and updating. Now, who likes to do maintenance and updating? Or maintenance, I should say, whether it's maintenance on a vehicle. Some people enjoy that, but most people don't. Maintenance of any kind is tough. It's hard work, but that's what it takes, as you can imagine, to have the kind of estate plan that actually works the way we intend it to do. One of the things that our client care program mentor in Boston, Massachusetts has taught us is if we imagine that someday we will pass away, and someday we don't know when that will be, where that will be, under the circumstances of when or where that will be, or how many assets we have at that time. What we're really doing here in estate planning is we are really speculating about the future. When is this going to occur, and will we be ready? With maintenance and updating, we can take a lot of those concerns off the table, and we can have more certainty, as we get back to that word, real certainty and assurance that the planning will actually work the way we want it to. And by the way, at final administration, at our passing or maturity, whatever we want to say here about this word, the process could be as inexpensive as possible, because we have done all the work throughout our lifetimes to make sure that we are keeping our documents updated, making sure our assets are aligned properly with our document, making sure that our estate planning attorney is in collaboration with our financial advisors and our CPAs, and that it's a team effort. This is how we avoid plan failure. So legacy planning, we could call it for whatever we want to call it, but legacy planning, as we would call it, incorporates these 3 phases of planning where there is an emphasis on education. The process, not a set of documents, is the plan. We want to maintain and update and fund and align our assets in the planning and around the planning, like asset alignment for retirement plan assets, annuities, non-retirement assets. How are those things going to pass? We're going to see a few slides on this subject. So let's define estate planning. You're going to define it for yourself, as I mentioned, but here we're going to give you a very, very basic definition. So if you have something to write with, you can fill in the blanks here. One definition of estate planning, to very, very simply start out somewhere, is to say estate planning is about disposing of your property the way you want, to the persons or organizations of your choice at the lowest possible cost. So here it again is the simple definition that might be something for you to work with. Estate planning is about disposing of your property the way you want to the persons or organizations of your choice at the lowest possible cost. So with that as our definition of estate planning, let's get into a question that many people have about wills versus trusts. And I know many of you may have this type of question, and the broader subject here is probate versus non-probate, wills versus trusts, or other non-probate transfers. But I'm going to stop right here and just ask Jeff. Jeff, do we have any questions yet, or should I just keep going?
No questions yet, Steve. You can keep going. I would encourage anybody to please go ahead and pose any questions that you might have. We're happy to answer them throughout the discussion.
Very good. So let's get into the wills versus trust discussion. This simple bullet point slide will give you a very brief overview, very brief but very broad overview of the probate process. So the probate process takes about 9 months on average. And this is just a bullet point summary of assets that have to go through probate. We're going to talk about that, but this is the overall process. So let's talk about a will. A will by its very nature is subject to probate. Probate is a process, as you'll see here, of public oversight. The registers of wills in each county, and there are 2 counties in Maryland that the Register of Wills actually is heard or is actually convened in the circuit court, and that is Harford County and Montgomery County. But in all other counties, there is what is called an orphans court, which is attached to the registers of wills. And that particular entity, the registers of wills and the orphans courts, provide oversight in the administration of estates to make sure that everything is fair, creditors have a chance to be paid, and everyone has notice, all of those things. So here we open an estate, as you see, there is an inventory due, claims of creditors have to be notified, so to speak. There has to be an accounting, and then there has to be administration accounts, or maybe one final administration account. This all occurs in about 9 months on average. The average cost of probate, according to AARP magazine, is around 4 to 7%. That's where we're getting that figure from. I would say in Maryland, it's around 4%, strictly because of the statutory fees that are allowed in court, in the orphans court, in the Register of Wills process. But certainly if you have a child or someone else who will serve as your personal representative under your will, and they do not charge a fee, it is possible that the cost of probate will be much lower than this. But on average, this is what the cost is. This is what a will structure looks like. You see here that our will is the driving force of the plan. And on either side of the will, we have financial powers of attorney on the left, advanced medical directive on the right. What is this all about? Well, if I had the ability to illustrate a whiteboard drawing for you here, what I would illustrate is that the will is the driving force. This is what happens at death. The powers of attorney and advanced directives, these documents are indicative of what happens during life. So we're trying to do 2 things here. We're trying to deal with what happens at death with the will, what happens during life with the powers of attorney and advanced medical directive. And as we get into that discussion about incapacity planning, you will see that those documents have what we call agents, financial agents, healthcare agents. What we're doing there is installing our agents so that we never need an adult guardianship. But back to the will by its very nature is subject to probate. But if you have no will, there will still potentially be probate on assets that are in your own name. So now we're talking about what assets go through probate. Assets that are in your own name with no beneficiary, meaning no POD, no TOD, and no beneficiary designation otherwise, and no joint owner. Those kinds of assets will go through probate. For those of you who may not be following me on that, I'll give you a few examples. A life insurance policy will typically have a beneficiary. That beneficiary is named, and as a result, there is no probate because that life insurance policy will go to that named beneficiary. The same thing is true of an IRA. However, if a life insurance or IRA, a life insurance policy or an IRA had no beneficiary, then they would be subject to probate. So there you have a non-probate asset that could become a probate asset. Here's another example. Let's say I have a rental property, and that rental property is in my sole name with no joint owner and no named beneficiary by deed. And there is a way of doing that called a life estate deed, which we'll discuss in just a moment. If I have none of those other structures in place, that rental property is going to go through probate at my death. A final example on the other direction would be, what if I have a joint bank account? If I die, then the surviving joint owner will succeed to that account. That is the surviving joint owner. No probate there. So probate versus non-probate, a lot of it has to do with how assets are owned and titled. Now, a revocable trust is an alternative to a will. So now we're talking about non-probate. But I want to make a big caveat or a big star here for you to see. You'll notice that where it says avoidance of probate at the top of this slide, and you'll see that there's a star there. The reason for that is that the revocable trust is a wonderful tool. It is a substitute for a will. It is an alternative to a will. So when we're talking about basic estate planning, we're talking about wills, we're talking about revocable trusts as an alternative to a will, but that revocable trust actually has to be funded. And this is a very confusing term for some people. The revocable trust has to be aligned properly. Your non-retirement assets like your house or a brokerage account that is not an IRA, those types of assets or cash have to be transferred into the trust. So there's two steps. The first step is to develop the trust just like you would a will. Then the second step is to align the assets properly. Now, with a fully developed trust, as you'll see here in this slide, we now will avoid probate. But a revocable trust is not all things to all people. Here you see that it has no asset protection. So the revocable living trust does not in and of itself provide protection, and it does not provide any tax savings. It does, though, have some ancillary uses. There are some nuances in the world of estate planning where revocable trusts are simply better than wills. But generally speaking, very generally speaking, with some exceptions, we can do the same kind of planning with wills and trusts as you can do with the other. It doesn't matter except for a couple of little nuances there. What we try to do is educate about what these are. Some people are going to want to do a revocable trust rather than a will. Other people may not care about avoiding probate, and they may just want to use a will-based plan. So here is what a revocable trust structure looks like. I want you to know that it is simply an alternative to a will. I want you to think a revocable trust is kind of like a contract. The contract is created by you. It is to have a private type of administration of your estate rather than the public type of administration of a will through the registers of wills. So here we see the revocable trust is the driving force. Down below, you see the powers of attorney and advance directives, just like the will plan. But you'll notice with the revocable trust, there is a backup will. What if you were supposed to put all of your assets in your trust, the appropriate ones, and you didn't do that? You failed to do that, and the assets were still outside of your trust at your death. Well, we would want some mechanism to sweep those assets up, put them back into the trust, and make sure that they were distributed the way that you wanted them done. So that's what the backup or pour over will is all about. We would also assign your personal property, your tangible personal property, furniture, belongings, jewelry. we would assign that to the trust, and we would also assign intangible personal property to the trust. So wills versus trusts, two basic ways of going when we're doing basic estate planning. One is probatable by nature, the process of the courts. The other one is non-probatable by nature, but only if we make sure that we have fully funded and aligned all of the assets. That is part of client care. That's part of the educational process. That's also part of the maintenance and updating process to make sure that that is done properly.
So Steve,
Now,
we do have a question.
thank you, Jeff. Go right ahead.
It was posed to me by email from one of our attendees. The question is, can distribution of assets to an adult beneficiary for inheritance purposes be age specific? In other words, there is no lump sum all at once, or there is an established timetable.
And Jeff, could you read the first part of that question again?
Yes. Can distribution of assets to an adult beneficiary for inheritance purposes be age specific?
Yes, so that's a great question, and the answer is yes. And I'm so glad you asked that question, because with wills or trusts, remember those are document-driven kind of situations. You can make distributions like that age specific. So absolutely you can. You can control how assets are passed down to a beneficiary and how they are distributed to a beneficiary through those documents and through what I would call further trusts for the beneficiary. So that's a great question, and the answer is yes. Now we're getting here into driving documents in different areas or different directions without the use of documents, meaning without the use of a will, without the use of a trust. And when we want to control distributions based on age or staging distributions, we can't really use these kinds of transfers. So I would think in terms of the will being category number 1, the revocable trust being category number 3, or however you would like to think of that. And here in the middle, we have what I would call non-probate devices or non-probate transfers, which many of you are familiar with: joint ownership, beneficiary designations, life estate deeds, transfer on death, payable on death. So let's go back to transfer on death. This tends to be a brokerage type account designation where we can say, upon my death, assets are transferred to the beneficiaries directly. Payable on death tends to be a bank designation for an account payable on death to a beneficiary. In trust for accounts, in my opinion, are similar to POD accounts. I don't see many of those in Maryland, but some of the northern states from New Jersey on up north, I've seen some of those types of accounts. So why wouldn't we just use all of these non-probate devices to transfer assets? Well, it's exactly what the nice person in their email had asked. What in essence, his or her question, what it means to me is, if I'm trying to control the disposition of assets down to my beneficiaries, and I want to stage it, or I have other reasons for protection or staging, then I certainly want to use a will or a trust with a further trust for that person to control how everything goes down the line. Here we have no control, although it does avoid probate. If we pass away first before our beneficiary, there is no question that this avoids probate. But most people are going to use a will or a revocable trust or another type of trust to control how distributions occur down the line for whatever their goals or whatever their reasons may be. The other reason that people use in general wills versus trusts versus these approaches, even though these do have their place in planning, we do use them strategically sometimes. But the other reason is that sometimes the orders of death are different than we anticipate. And as we've learned recently, life can throw out a lot of things that we don't expect. So that's why most people do not rely on this type of planning for their full estate plan. We're going to use wills or trusts 95% of the time, because what we're trying to do is control how assets flow down.
So Steve, going back to the trust, we do have a question related to that. The question is, does a pour-over will still go through probate?
That is a great question. So I'm going to go back to the trust diagram, and the answer is yes. So unfortunately, the pour-over will would be an example, depending on how you define plan failure. The pour-over will would be indicative of a plan failing, because if there were assets outside of the trust and those assets were probatable, meaning they had to go through probate, they would go through probate first, and then after probate would be distributed back to the trust, and then the trust would distribute the assets the way you wanted them to be distributed. Unfortunately, the activation, so to speak, of the pour-over will in that example means we haven't had a plan that worked the way we wanted it to. So part of maintenance and updating for someone who has a revocable trust is to make sure that the trust is fully funded and aligned, and that at our deaths, our pour-over will is basically just a stagnant, silent document that doesn't really do anything. Great question. Now, here is an example, I'll show you 2 slides, of us having a great will or a great trust. We have a wonderful document that you took the time and effort to put together, to give of your emotional energy and all of the things that people go through when they create wills or trusts. But look at what happened here at our death. We have this will or this trust, it's very thoughtful, but we didn't necessarily align the assets the way they should have been aligned. So here we have joint ownership money going to the survivor. We have POD and TOD and beneficiary designations. So if we had special provisions in our will or trust, for example, the nice question we had a couple minutes ago, if we were trying to control the disposition down to further beneficiaries, here we would have failed. So this is another example. We only can do as well as our asset alignment. So this is the second slide that really speaks to the same thing here. We've got this great plan, but we failed to properly align the assets because the assets are flowing outside of the structure that we built, if that makes any sense to many of you. So in the future, Jeff and I are going to change this particular slide because it says funding is the key to estate planning and elder law, and that is true. But the word funding causes a lot of people to be confused. And I think it would be better if we said asset alignment is the key to estate planning and elder law, or any estate planning. One more thought on this subject. I'm sorry to go back one more slide. We talked about our client care program, and our mentor at the Client Care Academy has gotten us to understand that something that we intuitively understood, and I think you will intuitively understand this as well. Not only is asset alignment the key to estate planning, but it may actually be the most important thing in estate planning. How assets are owned at death versus how we want those assets to flow in our estate plan arguably is the most important thing in estate planning. Okay, I know it's a Monday afternoon. It's an unusual time perhaps to talk about a depressing subject like incapacity planning or death, but let's get right in now to the incapacity planning portion. We talked about powers of attorney, advanced directives, and for those of you who may by now understand what MOLST is, the medical order for life-sustaining treatment, which is now mandatory in Maryland and at least 4 other states, I will talk to you about the basics of MOLST, the medical order. So just looking at this simple diagram, we know that whether we have a revocable trust plan or whether we have a will plan, we know that no planning is complete without thinking about incapacity planning. So here we have powers of attorney, and notice I've said plural powers of attorney. In modern estate planning, we would typically, even though nobody's plan is the same perhaps, we would typically think in terms of using the Maryland power of attorney, which is enforceable by law. We are very lucky in Maryland now to have this set of laws, the Maryland Power of Attorney Act since 2010. This power of attorney is enforceable if we have to have it enforced by our agent, which hopefully will never be needed, but it does have the force of the law behind it. And it has many accountability measures in the law that our fiduciary, our trusted advisor, has to be accountable. And this was not the case before in the law. And by the way, powers of attorney that were executed prior to 2010 definitely need to be updated because those are not enforceable under the old law. So that's why we need to be thinking about updating powers of attorney. The general durable power of attorney, we would think as a layered approach of having the Maryland power of attorney for basic needs, and then having a more powerful or more broad general durable power of attorney for more all-encompassing estate planning ideas. So the typical Maryland statutory form, which is now in several states like Delaware, West Virginia, they have their own forms. DC has always had their own statutory form. New York has always had it, and many other states have it now. Those documents are very basic. They're good to have, but they don't necessarily provide all the scope of powers that someone who is doing estate planning would want or need. So we want to do a lot of thinking about those because some of the broader powers are very, very broad. They are kind of scary, like powers of gifting, powers of whether or not your beneficiary can establish trust, whether your agent can establish trusts on your behalf, whether your agent can be compensated. All of these things are counseling issues that you have the ability to customize your powers of attorney to make sure that you're comfortable with the kind of powers that you're giving someone. On the healthcare side, we are appointing our healthcare agents as opposed to appointing financial agents on the financial side. When we have appointed our healthcare agents and we've appointed our financial related agents, we are doing something very significant that most people don't think about. We are avoiding guardianship. So remember, we're not talking about the guardianship of a minor, we're talking about the guardianship of an adult. So as we age and as we continue to become more mature, we certainly don't want to lose our legal rights. So with these powers of attorney and by naming your agents, and by the way, we want to name as many agents, in my opinion, that are reasonable under the circumstances. By having these agents, we are doing everything we possibly can to avoid losing our rights to a guardianship of the property, which on the left side here is the issue we're talking about with our financial assets. And we don't want to lose our legal rights in a guardianship of our person on the healthcare side. So that is the driving force behind this incapacity planning. It's not just to have a mode of taking care of ourselves should we become incapacitated and someone will step into our shoes and take care of us. It's a question of making sure we don't lose our legal rights in guardianship. I'll give you two quick examples, and I like to do this in live workshops. So hopefully through this webinar, you'll get the idea of what I'm trying to convey. I'm not trying to scare you about this issue of guardianship, but it's something that we need to keep in mind. So let's talk about the financial side first. Let's pretend that that someone we know that's married, this person is married in my example, they end up in a car accident this afternoon, God forbid, and they are in a hospital. And they're not doing well, and their spouse comes to the hospital. So my question for you to think about, and it is a little bit of a trick question, I apologize. The question I want you to think about, this married person has no financial power of attorney. They have no financial power of attorney, and they have many assets in their own name. Can their spouse make transactions or take care of those assets for this person if they have no financial power of attorney? I want you to think about that for about 5 or 10 seconds. And the answer is no. The person who is their spouse, just because that person is married to the person who is now injured or disabled, means nothing with regard to the financial management of that person's assets. So the spouse of a person who does not have a financial power of attorney, but has assets in their own name with no joint ownership, okay, that person will, that spouse will not be able to manage their assets. And the reason for that is there is no substitute for guardianship on the financial side. So on the financial side of things, we either have a power of attorney that names our agents or we don't. And that means that that person, meaning the disabled person, would have to potentially have a guardianship of their property and lose their legal rights if 3 or 4 weeks later they still were not doing well and couldn't manage their affairs. On the healthcare side, let's take that same example. A married person goes to the hospital because they've been injured. They are married. They do not have an advanced medical directive. Their spouse comes to the hospital. Here's the question I have for you. Can the spouse make a healthcare decision for the disabled or injured spouse? And I may be tricking some of you. The answer here is yes. On this side, on the healthcare side, there is what is called a lesser restrictive alternative, and that's called surrogate decision making. So in the Code of Maryland, there is a list of priority about who can make healthcare decisions for another person. And because this injured person is married and they have a spouse that came to the hospital, that spouse should be able to make healthcare decisions right then and there, even if he or she does not have an advanced medical directive appointing them. So why do we still worry about guardianship of the person then on this side, on the healthcare side? And the reason is that we just never know what the circumstances are. Maybe the spouse was also injured. Maybe there are no other persons that are in the list of priority. And on top of that, we would all want to fill out, ideally, an advanced medical directive, especially under these circumstances that we're living in today, to outline our healthcare decisions, give people an idea of what we want for end-of-life decisions in advance and any other healthcare instructions. So we're going to get to MOLST here before the end of the presentation, so I'll save it for right now, but I'm going to go to a further slide. This is an example of avoiding guardianship. We have the financial side, we have financial agents, we have the healthcare side, and we have our healthcare agents. So even though we're going to talk about MOLST, the medical order for life-sustaining treatment, do not be fooled and think into thinking by what any person says to you that the advanced directive is no longer important. It is important because it gives the world an idea of what you want as far as your healthcare decisions and your thoughts and feelings, but it also provides for your healthcare agents, which avoids guardianship of the person. Now, back to the financial side, I'm not going to spend a lot of time on this, but we talked about the Maryland statutory power of attorney. We talked about it being a power of attorney that was basically covering a lot of basics. It's a basic power of attorney. It was meant for the average person. It was meant so that if you are a resident of Maryland, you can have assurance that if you are incapacitated and you need someone to take care of your financial affairs, that they have a tool that can be enforced to do that. But it was not meant for comprehensive estate planning as far as the estate planning community is concerned. There are two types. One is a simple statutory form that we've been talking about that is only about 5 pages. Then there is a long Maryland statutory form, which is literally a long form, and there is nothing wrong with this power of attorney. It's a very broad form. There's nothing wrong if you use it. Nothing wrong with that. The problem is in the estate planning world, from our perspective, it doesn't allow a lot of flexibility. These are designed for one thing, and that is to help people who are residents of Maryland have a basic power of attorney. So what we recommend is that you have a Maryland simple short form power of attorney as your basic form, but then that we customize a broader, general, durable power of attorney. What we're getting to in the following slides are just some of the reasons why you might want to have that broader power of attorney, because the simple Maryland form is probably just not enough for someone who does estate planning. And remember, the person who does estate planning in today's world is not the average person. Remember, the average person doesn't even have an estate plan. So here we're talking about estate planning for someone who is customizing and building the type of estate plan that they should really have. Powers of attorney can be effective immediately, or they can be effective upon your disability. This is a counseling issue. Also, it's possible to hold powers of attorney in escrow arrangements. Some people will say, well, I want it to be effective immediately as to my agent, Steve, but I don't want to give an original copy of my power of attorney to my agent. Would you please hold it in your office and then release it under certain circumstances someday if it's ever needed by my agent? So this is a counseling issue. Some people think they want their power to be, the power that they're giving their agent, to be effective immediately. Other people say, that is the craziest thing I've ever heard. Who would give someone the power over your affairs immediately? So we talk about making things contingent upon disability. Usually evidenced, by 2 physician statements. Again, this is an individual counseling issue. Jeff, I'm going to take just a sip of water here and see if we have any questions that anyone wants to ask.
No questions right now, Steve?
All right, no questions yet. So we're just going to keep right on going.
Taking everything in.
Thank you, Jeff. All right, so far we've talked about many things. Now let's get to healthcare decisions more specifically. So the advanced medical directive can be executed in different ways. Our firm, Elville and Associates, recommends right now that every person in Maryland should have an advanced medical directive with this COVID-19 situation that we're dealing with. You can get a form from the Attorney General. You can get a form from us. You can use a form on the internet called the 5 Wishes, which some people like that format and some people don't. It is possible to create an electronic advanced medical directive. It is also possible to create an oral advanced directive. If you find yourself in a hospital situation and you have no advanced directive, you should be able to dictate one orally to the staff there at the hospital, and there are protocols for that. So the advanced medical directive, the one that we recommend right now is the Attorney General's form. This is one that is very, very customizable. How customizable? Well, we've given you several instructions here, or bullet points, I should say. Most people don't do this. Most people do not customize these forms the way I'm recommending that you do. And there's no requirement to do that. But I want you to think about this. Someday, God forbid, if you need someone to act for you for your health care and you were not able to make your own decisions, what would you want them to know about your preferences? Would you like to have everything that you've said enforced literally, or would you want that person to be able to be flexible in the decisions that they're making and have the flexibility to change your decisions? When will their power be effective? I'll give you an example of some of the things I've heard and seen over the years in these documents. Some people will say nothing as far as their preferences. Some people will say, I want to be free of pain, or I wish to reinterpret or re-summarize this particular health choice that the Attorney General has given us here. Some people will say, I need pastoral counseling at this time of my life. I'm a very religious person. No limit to what you can do to customize the advanced medical directive. And for some people, this is the most important document of all. So it is possible that on this call, we're talking to someone on the call here who does not have an advanced directive or has an old one and has not revisited this document for many years. I strongly encourage you to to at least have an advanced medical directive during this crisis time in the world. And if you don't, that you will let Jeff and I know so that we can help you implement one. So the advanced directive, very important because it sets forth your personal preferences, and with the appointment of agents in that document, it avoids guardianship of the person as much as you possibly can. Now, here's the MOLST, and we'll talk about this a little bit. For those of you who have not heard of this, this has been in the law since around 2013, 2014. It was a national initiative called POLST, Provider's Order for Life-Sustaining Treatment, but Maryland calls it MOLST. Now, MOLST is required under certain circumstances. I won't go into that today too much. I'll just say under most circumstances, it is required within 48 hours. So let's say that I was not in a good health situation. I ended up having to go to a rehab center. I have to have a MOLST form signed by a doctor or nurse practitioner within 48 hours. That's the typical example. If I'm in an assisted living, if I'm living in a continuing care retirement community like Charlestown, I'm going to be required to have a MOLST. Now, MOLST is not required for hospitals unless I've been in a hospital for a long period of time. But I can tell you from experience in all local hospitals that hospitals are using the MOLST form every day. So we have to assume that if we are in a facility of any kind in Maryland, or if we're having a procedure in some facilities, we are going to have a MOLST form. What is the MOLST? Well, it's difficult to describe on this webinar. The MOLST is a doctor's order as compared to an advanced medical directive, which is signed by you, and it basically goes into your preferences for end-of-life situations and your general healthcare preferences. So here we have the advanced directive. On this side, we have MOLST, which is required under certain circumstances. And in the middle, we don't have a whole lot there that makes a lot of sense to many people about what is the relationship of the advanced medical directive to the MOLST form. And we don't have time, in all fairness to our viewers today, we don't have time to adequately illustrate some of the confusion that's going on in the estate planning world about what's the difference here between advanced directives and MOLST. I will say this, if you will go to the Attorney General's website, marylandattorneygeneral.gov, marylandattorneygeneral.gov, I want you to review Maryland healthcare policy on that website. I want you to watch the MOLST videos and training that they have on there to get a good idea of what is the difference between these two things. And on that website, you should be able to see something called the MOLST, or the Healthcare Decisions Worksheet, that I have here on the slide. And I want you to see that, and I want you to kind of get your mind around the fact that perhaps for some people, there will be an advanced directive. God forbid, if the person is in a facility, they'll have a MOLST form. But that person may also want to be proactive by having completed a healthcare decision-making worksheet. For some people, they will not do that. They may prefer to let their healthcare agent deal with MOLST. Other people will be very proactive and want to deal with that. So hopefully that gives you a little bit of an idea of how you need to educate yourself about healthcare decision-making in Maryland in 2020, especially now. So I'm looking at my clock, and it looks like we've been going for just a little bit less than 1 hour. We've got more information to cover. So unless there are further questions right now, I'm going to keep going. And we will be done in plenty of time and have time to take questions. Now, I want to switch now to more of the specific information for planning. So let's talk about basic estate planning versus elder care planning. What is the difference? So far, up until this point, this webinar is about estate planning essentials and elder law essentials. Here we're getting into what is the real difference. Well, in estate planning, we're talking about what happens at death, what happens during life. So let me cover that again. What happens at death with wills and trusts? What happens during life with powers of attorney, advanced medical directives? Now, remember that a revocable trust, for those of you who might have a revocable trust or you're interested in a revocable trust, the revocable trust has both elements. The revocable trust has death elements. This is substituting for my will. And it also has lifetime elements. If I become incapacitated and I've properly aligned my assets in my revocable trust, my trustee is now going to step into my shoes and make sure that my assets are managed. So that's very similar to the power of attorney, which manages non-trust assets. So if I have a trust, let's say my house, my cash, my brokerage account, my savings bonds, those things are in my trust. But my 401k, my IRA, my life insurance policy, my annuity might be sitting out here outside the trust. So in basic planning, we have in a revocable trust, we have trust assets and non-trust assets. I say all that to say in estate planning and elder care planning, those concepts are the same. What happens at death, I should say, and what happens during life. So the big difference is in elder care planning, we're focused a lot on what happens during life, of course, because we're focused on what happens for incapacity purposes and disability, basically. So to me, the difference is estate planning traditionally is about how assets are left to our loved ones and tax considerations. Elder care planning is very much the same with this difference. There is a focus on asset preservation for long-term care, and there's a focus on disability planning. So to me, that is the difference. And of course, this whole buzzword of elder law started in the 1990s and has continued to today. So in elder law, we're talking about asset preservation. What do we need to do if we have a long-term care or a care situation of any kind? What do we do to pay for that care? What do we do to preserve assets? I personally am experiencing something in my own family right now with a loved one who has memory issues and dementia issues. So I know from personal experience what is happening and from dealing with thousands of clients about these issues. In these kinds of situations, instead of just having what I would call pure estate planning documents, we want to start developing ideas of flexibility in those documents, even more flexibility than we normally would, for the possibility of asset preservation, for the possibility of transferring assets between spouses or others. And as we get to this next bullet point, the idea of this big word, divestment of assets. Some people say to me, Steve, what do I have to do to preserve assets in the long-term care way of thinking, in the long-term care context? Well, in simple terms, you have to be willing to divest of your assets in some way, to give away your assets in some form. Because if we part with control of our assets, Medicaid, which I want you to think of as a very broad umbrella term. I want you to think of Medicaid in several different ways, but in this particular context, I want you to think about Medicaid being the umbrella mechanism that pays for about 85% of all long-term care across the country. So as we're talking about divesting assets and starting the Medicaid 5-year period and all of these things that you may have heard of, we are talking about doing these things with these rules, these Medicaid laws that govern how Medicaid is distributed across this country. We want to do that with those laws in mind. So there is something that many of you have heard is called the 5-year look-back period, and that was changed in 2006, 2005, and 2006 with the Deficit Reduction Act of 2006, where the transfer period, so to speak, or the look period, went from 36 months to 60 months for most assets. So what we're talking about here is something that traditionally has been called the look back period, I'm going to encourage you for asset preservation purposes to think of that as the look forward period. I want you to think about, if I were to divest myself of assets, give my assets away in some form to my children or others, what would I be doing? Well, I would be looking forward for 60 months. We're looking forward for 60 months, 5 years, and if we can stay healthy for 5 years or 60 months past the time that we gave our assets away, that we divested our assets in some form or fashion, now we have placed our assets out of the reach of a Medicaid spend down. That's what many of you have heard about. So that's what I'm talking about with divestment of assets. Now, traditionally, individuals and couples would simply divest assets by giving them away to children or grandchildren. We don't recommend doing that. We recommend, as I say here in my several bullet points here, we want to do several things at one time. We want to hit several birds with one stone, so to speak. We want to be able to control a little bit about what we're doing when we give away those assets. We want to take into consideration the tax ramifications of the transfer. We want to make sure that the assets that we are giving away are not completely beyond our control. We want to make sure that the beneficiaries that we're giving away these assets to, or for the benefit of these people, we want to make sure that they're not in the midst of a divorce, that they're not going to lose the assets to a creditor. So we want to keep all of these things in mind as we're making these divestments of assets. And typically, we would not recommend outright transfers. We would not recommend that you, as an older person, let's say, give away your assets to someone outright, where you might lose a step up in cost basis for income tax purposes, or you may lose complete control of the asset, or you have the beneficiary lose the asset to a creditor. All of these things have to be taken into consideration, whether it's a Medicaid type situation or a VA or veterans benefit type situation. So I'm going to fast forward to my next slide just to remind myself, and I'm going to go back to where we were just to finish up the discussion here about Medicaid and veterans benefits. So for Medicaid purposes, we have this 5-year period, and we have to plan around that if that's our goal. For some people, there will not be a divestment of assets, and we're going to talk about that in a few slides from now as we talk about asset protection. But for some people that want to preemptively or on a pre-crisis basis start doing asset protection, then they're going to divest assets, and when they do so, we strongly recommend the use of an irrevocable trust that we would call a Medicaid trust as kind of a term of art for how that trust is designed. For veterans, we're dealing with the potential to get VA aid and attendance benefits, which is a mouthful. It's a VA pension, and we know that veterans can benefit greatly from this source of tax-free income that can make a huge difference for people who are not in long-term care facilities, people that are living at home or some other arrangement, people that are living in assisted living that can still receive the veterans benefit. So first thing we want to ask, if we're dealing with someone who needs care and they need money for their care, we want to find out if they're a veteran and whether they would be eligible for the veterans benefit. Unfortunately, the VA changed its rules in 2018, in the fall of 2018, and now has implemented a look-back period, so to speak, for the transfer of assets for veterans benefits, whereas prior to that, there wasn't a look-back period. So all of these things are part of elder law, and of course, arguably, nursing home placement, facility placement, housing, special needs, all of these kinds of things are part of elder law. But I wanted to make a few distinctions between estate planning and elder law. All right, Jeff, I'm taking a sip of water. It's about 10 after 2.
I do have a question, Steve. Going back just a little bit to the Advanced Medical Directive and MOLST. The question is, in an end-of-life situation, Which takes precedence, MOLST or the Advanced Medical Directive?
That is a wonderful question. I am not a doctor or a nurse, but I'm going to go out on a limb and say, subject to our further consultation with a life care manager, nurse, or a doctor or nurse practitioner, that I would say the MOLST is going to take precedence, because that is talking about the current situation, whereas the Advanced Medical Directive is more of our general wishes. That's a wonderful question.
Okay, thank you.
All righty. Now I'm going to switch gears on everyone as we start heading toward the home stretch of the presentation. Let's talk about estate planning now that we kind of digressed into elder law. We're going to come back to that in just a minute. Let's talk about what I would call conventional estate planning. So we're living in a world now where there's never been a better time, or more favorable time, I should say, than doing estate planning with our unprecedented exemption amounts. So estate tax, meaning the death tax based on the value of one's estate at death, has never been more eliminated. Estate tax has been eliminated for most people. Our current exemption amounts federally are $11.58 million per person, or over $23 million between a couple. For Maryland, our estate tax exemptions are $5 million per person and $10 million for a couple. Now, in this changing environment we are in, who knows how long that will last? Right now, those exemption amounts are slated to come down, or at least the federal exemption is slated to come down in 2026, which is quite a long time for now, but we'll be here before we know it. So we have to keep an eye on the exemption amount. But for most people, estate tax has been eliminated because of these huge unprecedented amounts. If you're married, and I will apologize here to folks who are not married, but if you are married, you need to understand that the federal government, believe it or not, has simplified estate tax planning for most people by something called portability several years ago. So in a simple way of describing this, portability has to do with the ability of a surviving spouse to elect and port the exemption amount of a deceased spouse. So let's say a spouse dies and they have an $11.58 million exemption amount. The surviving spouse has 24 months to make what is called the portability election. And that's what this next bullet point is about, using the deceased spouse's unused exemption amount. Okay, the DSU, as the new federal law calls it, the deceased spouse's unused exemption amount. This is assuming that it was never used before. So a surviving spouse can choose that exemption amount and have 23 million of exemption. Now, most people would say, Steve, why do I need to spend the extra money to fill out the estate tax return to make the portability election and have $23 million of exemption? Why would I need to do that? And the answer is, well, you might not want to do it, but you very well need to consider that, because the government is being very liberal with this. They are giving you 2 years to make this election. And remember, the exemption amounts are coming down possibly in 2026, if not before. So when you make this exemption election called portability and you're locking in the 23 million, or if the exemption amounts are cut in half in 2026, which is what we anticipate, you will be locking in that amount at that time. The government can never claw that back from you. So there is a new federal Treasury regulation that says once a person has elected portability, the government may not take it away from you. So I encourage you to consider portability, even if you think you don't need it, because you're locking in exemption amounts of huge amounts that exempt right now 40% estate tax. So the federal estate tax rate is 40%. And when you're locking in those exemption amounts, you are exempting your family from that 40% estate tax. When I was a young lawyer, that used to be 55%. So that's quite a lot. In estate planning, We need to be worried about marital control for those who are married. I apologize to the single people. If you're married, part of your planning is deciding whether or not upon your death you wish to control the disposition of assets to your spouse so that those assets go the way you want them to go, usually to your children at the time of your death. So there are uses of trusts under wills and trusts, further trusts, to have marital control. Remarriage protection is part of this issue of using these types of trusts. Another protection, of course, is getting a prenuptial agreement or even a postnuptial agreement. But let's talk about the prenuptial agreement. That is a very, very important part of asset protection, which we're going to talk about in just a minute. And many of you who follow the legislature may know that Maryland just passed a law recently called the New Spousal Elective Share Law. The New Spousal Elective Share Law is the law now after several years of trying to get through the legislature, and it will be effective this fall. It will be effective in the fall of 2020. What you need to know if you are married is that if you ever remarry, you should be very aware of this new law, and you need to get a prenuptial agreement to protect yourself if that's your goal. If protection of children's shares, grandchildren's shares, nieces and nephews shares, if those are a priority for you, if that's a goal, we want to protect that. We don't want our new spouse, if we remarry and you were to die first, we don't want our new spouse to be able to get any of our assets if that's not what we want, by using prenuptial agreements and thinking seriously about the issue of marriage protection.
Steve?
Yes, Jeff.
We do have a question. The question was, are there similar options for life partners?
That is a great question. The federal laws and state laws and the estate planning laws that are centered around them, or state tax laws, are geared more towards spouses, of course, and the advantages of marriage, so to speak, for taxes. But if you are not married and you live with a life partner, the same kind of protection can be afforded, or the same kind of control can be afforded in your planning. It's just that you don't have the same tax favored treatment as you would if you were married. But that's a wonderful question, and it is true that upon your death, you can control how assets go to your surviving spouse and how they flow down from there. So great question. All right, well, I can't see you on my end, but I just think that you're a very patient audience. I just feel that. And I promise here, after about an hour and 15 minutes, I'm now on the home stretch. And we're going to talk a little bit about something called asset protection. So I always like to set the stage of what is asset protection. Many people ask me this. I think there are various aspects of asset protection. One of them is lifetime protection. You know, what do we have now, just as we get up every day and live our lives, go to work or be retired, whatever our situation is, what do we have that protects us now without us having to do anything? I like to point that out. What is long-term care asset protection? We talked about that just a little bit ago. I'm going to get into more details about that. We talked about how do we think about preserving assets? Do we have to divest ourselves? What are other thoughts and techniques about that? And then asset protection at death. So asset protection at death, you're going to find, is pretty straightforward. It's one of the other than the whole issue of death, I hate to say, is one of the easier concepts to think about in estate planning. So let me get into each one of these in more detail as we start to wrap up. So lifetime asset protection, I just want you to imagine and envision what you may already have as protection in your own life. So when we're talking about asset protection, we're talking about bankruptcy protection. We're talking about protection from the claims of creditors, okay? And it also, of course, could have an aspect of, marriage protection and those kinds of things that we just talked about. So if you're married, you know that you should know that you have basic asset protection as tenants by the entireties. A good example is your home. you have a home, and 99% chance that home is titled as tenants by the entireties. Every once in a while, I've run into a couple where the home is not titled as husband and wife, tenants by the entirety. I want you to check your deed. Don't panic, 90% or above chance that you already are titled this way. Think of tenants by the entireties as this. Here's your house, for example. It's owned as husband and wife or spouses. It's spousal ownership. It's an undividable whole. If this person here, this spouse, got sued and there was a judgment against this person and there was no judgment against this person, the house cannot be torn in half. It's an undividable whole. That is very desirable form of asset protection, even though it's somewhat limited, because if both of you got sued, then there would be no asset protection, but it's a very baseline protection. And Maryland and Delaware, for example, are huge tenants by the entirety states. So I want you to think in terms of, are there assets that I could title as husband and wife other than my home? I'll give you a very brief example as we wrap up. Maryland several years ago said that if you own property as husband and wife and you transfer that into a trust, into a revocable trust, you should retain and you will retain the same husband and wife protection after you transfer that asset into the trust as you had before. So that's a very powerful thing. So we want to make sure that if you're married and you don't have your assets titled as husband and wife, tenants by the entirety, you should do that. Taking that a step further, many people will have their house, of course, titled as husband and wife, but there might be a brokerage account, and sometimes a large one, that is not titled as husband and wife. And I've seen this happen, and I've seen people be sued and lose half of their joint brokerage account. And some people would say, well, Steve, I thought that a husband and wife account was joint. The answer is yes, it is joint, but it has the umbrella protection of husband and wife. So if we have a brokerage account, you should ask your broker dealer, can I have this titled as, and I'm talking about a non-retirement account now, not not an IRA and not a 401k or not a 403b. We're talking about non-retirement assets like a brokerage account. Title that as husband and wife, and now you have better asset protection if it's appropriate under your circumstances. Switching to life insurance. Life insurance is protected from the claims of creditors, both the death benefit and the cash value in Maryland, so long as a spouse or child is listed as a beneficiary. And I've actually seen cases where this was not the case and the life insurance proceeds or the cash value was subject to bankruptcy division. For the person who asked the question a few moments ago about not being married, I apologize about all of this about marriage. But I'm trying to point out the different approaches the law takes for asset protection. For annuities, the same situation is true. If you're married, if your spouse or child is the beneficiary, then there is asset protection. If you're not married, but your child, I should point out, if you're not married, but your child, you have a child, and that child is the beneficiary of a life insurance policy or an annuity, you still have protection. Qualified plans and IRAs, these are protected from creditors. IRAs have different rules, but generally speaking, these are protected from the claims of bankruptcy creditors. So that's why it's wonderful that most people are fully funding their qualified plans and IRAs because they are protected. Now, when we pass away and we leave our IRAs to our children, grandchildren, nieces and nephews, or others, those beneficiaries are going to have no asset protection unless we leave the IRA into a further trust for them. We call that an IRA trust. So you can protect your beneficiaries from the claims of creditors and bad marriages and so forth. And then the question becomes, well, how is that taxed? So I'm going to talk about that here real quickly at the end of this slide. But just know that inherited, or what we call beneficiary IRAs, are not protected from creditors. We have to make sure we try to do that if that is a goal of yours. Lastly here, domestic asset protection trusts. Some of you on the call might own businesses or you might have specific concerns about lifetime asset protection where your other assets, other than these particular types of assets, need to be protected. And fortunately, in this country, we have several asset protection jurisdictions. Maryland is not one of them, but Delaware, Nevada, Alaska, South Dakota, Wyoming, these particular kinds of places are asset protection jurisdictions, and we can have exotic trusts, so to speak, in those states if we need to do that to protect assets. Before I move on to another type of asset protection, and because we have up to 2 hours, right, Jeff? I'm going to keep talking here about the Secure Act. So let's go back to problems for IRAs. And I'm just going to spend just a little bit of time on this, and we'll move on to other asset protection, and then we'll be done. And on January 1st, 2020, the Secure Act, and if you haven't read about this, I want you to Google this, capital S-E-C-U-R-E, Secure Act. Most of you are aware of this by now. It expanded retirement plan benefits and the ability to participate in retirement plan benefits for most Americans. It modified certain rules for retirement plans, but the main thing it did in estate planning for retirement plan assets was not good. It limited the ability of a healthy beneficiary. Let's say you have a healthy child, a healthy grandchild. That child or grandchild receives an inherited IRA from you. Because they are healthy after January 1st, they no longer will be able to defer the taxation forever and only take a minimum distribution and just let it keep deferring and growing. The government, unfortunately, is limiting that to 10 years. So not good news if you've not heard that, not good news for estate planning clients. We are trying every way we can to strategize around this. Just know that for healthy beneficiaries, they will only be able to stretch out the IRA distributions for 10 years. And this is going to cause a taxation question, and it's also going to cause a planning question for many people about how to plan for their IRAs. Now, fortunately, and then we'll move on, there are several exceptions, and these are the exceptions to the Secure Act, basically. Spouses are exempt, minor children are exempt, people with disabilities, people with special needs are exempt, people with chronic illnesses are exempt, and then people who are no more than 10 years younger than someone. For example, if you have a sibling who's 5 years younger than you, that person is exempt. If you have a sibling who's 5 years older than you, that person is exempt. And the good news for folks that have loved ones with disabilities or chronic illnesses is not only are they exempt, but special needs trusts for them are also exempt. So I wanted to give you a little bit of a flavor of the Secure Act as we were talking about lifetime asset protection for IRAs. We're almost done. Asset preservation for long-term care. Well, we talked about this a little bit a few slides ago. We talked about the uses of Medicaid trusts, the uses of veterans trusts, and why most people, not all, but most people will use those as a control mechanism if we're going to give away our assets, divest our assets for Medicaid purposes. So what we're really talking about there is pre-crisis planning. We are trying to get ahead of the 5-year curve. We are trying to get ahead of things and trying to do it while we're healthy, because our goal is to get through the 5 years. We want to successfully get past that 5 years with no need for long-term care. And we're either going to get through the 5 years because we're healthy and we never needed long-term care. We're going to get through the 5 years because we have long-term care insurance or some other long-term care hybrid product that helps us get through the 5 years. Or we're going to get through the 5 years because we kept certain monies to finance our care through the 5 years, and we divested other monies to a trust, for example. Trusts under wills. Under federal law, if we pass away and we establish a trust for someone under our will, not under a revocable trust, but under our will, that trust that we establish for that person is exempt. It is exempt for Medicaid purposes. So here's an example, a spousal situation, or maybe a non-spousal situation. But we have normally a spousal situation and one spouse has an impairment. One spouse has a dementia or is ill. We transfer assets from the disabled spouse to the name of the well spouse many times under proper circumstances. This is a counseling issue. And now the well spouse leaves a trust under his or her will if they die first. So many people under these situations say, I'm in a crisis. This is not pre-crisis. I'm kind of in a crisis here. What can I do to plan? So that's a technique that's widely used to allow a healthy spouse who's not likely to die first, but if they did die first, they can establish a trust under their will for the benefit of the disabled spouse. That trust is exempt for Medicaid purposes, and then at the disabled person's death, it passes to children or other beneficiaries. Crisis planning, again, this is a situation where someone is in a crisis, they're in a nursing home, or a spouse is in a nursing home, and we cannot do a 5-year pre-planning type of plan. We are stuck with a crisis plan. So just know that this particular term, the half-loaf strategy, we would call that the gift and return strategy or the rule of halves strategy. Just know that if we've done no pre-crisis planning, that we still can preserve, hopefully under the current law, up to 50% of the remaining assets, even if we have done no pre-crisis planning. Life estate deeds are one method where if I say, I'm giving away my property to another person, but I'm retaining a life estate in the property, no one can ever kick me out. That is a particular Medicaid planning tool that starts the 5-year period. It means I have no right to sell the property, which is pretty scary. So we have to think carefully about that. One thing I want to point out here about this particular thing, this particular subject of long-term care asset protection, if you are married, then remember, as long as you are well and your spouse needs a nursing home, with proper spend down for a Medicaid spend down, you can preserve a lot of your assets and in some cases nearly all of your assets with certain strategies. So these bullet points do not encompass that particular situation. So we can do pre-crisis planning. If we've done no pre-crisis planning, we hopefully can do the rule of halves planning in a worst case scenario. But if you're married, remember, as long as you're well and not in a nursing home, with proper advice and the proper techniques, you can preserve you should be able to preserve most of your assets, except for issues related to income tax. So one of our last slides here, maybe the last slide, is we want to talk about asset protection for spouses, children, and grandchildren, and others. And this would apply to the person who said, what about me if I'm not married and I have a life partner? Anyone who is a survivor, they can have protection as well. So far for asset protection, we talked about asset protection during life, asset protection for long-term care purposes, and now finally asset protection at death. So that's what this slide is about. So trust planning for spouses, we alluded to that a few minutes ago. If I pass away, I can leave assets to my spouse outright, no control, no asset protection. The assets are now in the name of my surviving spouse. If I leave assets in a further trust, okay, whether it's for a spouse or whether it's for children or grandchildren, partners, nieces or nephews, whoever it may be, I can make that trust what is called a spendthrift trust. So here's my will or trust. I leave a further trust for someone. I'm giving them a shell of protection, okay? Then the question becomes, well, if I've protected them and they can't give the money away to creditors and creditors can't get in the trust, do I want to give the beneficiary of the trust any control? So a very popular technique these days is to give a beneficiary control of their trust. Sometimes that's a good idea, sometimes it isn't. Generally speaking, the less control they have, the more protection they have. So this goes to how are we going to structure the trustees which goes back to education and taking lots of time in the design. Some of you may or may not have heard of something called the trust protector concept, or what Maryland calls the trust advisor. So since 2014, Maryland allows the appointment of someone I will describe as a trust protector, a special fiduciary who has limited powers to direct a trustee. Let's say that you had appointed a trustee and it's 25 years later after your death, and that trustee is not doing a good job. That trustee is not taking care of things and not managing the trust assets, or that trustee is ill and won't resign, won't step aside. The trust protector has the authority to remove and replace that trustee. Trust protectors can amend the trust. In the old days, many years ago, it was thought that trusts could not be amended unless they went to court, or we went to court, so to speak. But now there are many ways to potentially amend a trust. Using a trust protector is one preferred way of doing it. Again, this is not a requirement, and it's going to be specific to what your goals are and needs are, and your ability to really think in terms of flexibility, which we generally recommend, but it's not for everyone. Powers of appointment. When we leave assets in further trust for children or grandchildren or spouses, do we give them the ability to give it to whoever they want at their deaths, or do we lock that trust down more and make sure that it flows down the generations? There are counseling issues that have to do with this, and there are also issues that have to do with asset protection. How we structure that can determine whether or not creditors can get into the trust. And lastly, but not least by any means, special needs beneficiaries. We talked about the Secure Act. Many people are going to leave retirement plan benefits to a special needs trust for their loved one. And fortunately, under the law, if that special needs trust is drafted right, which is a big if that attorneys have to make sure happens, then the trust itself is exempt. And when retirement assets come in that trust, those retirement assets can be deferred as long as possible, and the taxation deferred as long as possible, while still providing the money for the beneficiary. But getting away from retirement assets, many people are going to leave life insurance and other non-retirement assets into a special needs trust. Those beneficiaries are protected under the Maryland Discretionary Trust Act from fraud. They're protected from the assets being considered available for Medicaid purposes, and from spendthrift creditors and everything else we've talked about so far. Special needs trusts are different than what I will call general needs trusts, and that's beyond the scope of today's presentation. But all of that has to do with understanding those three tiers or three categories of asset protection. So with that said, I'm going to turn it over to Jeff here in just a second. I want to thank you for sitting through a little bit more than an hour and 35 minutes of this estate planning and elder law essentials. I hope you'll use this presentation as a tool. And many of you have existing documents. I want to encourage you to use us as a resource to review those documents and make recommendations. We do not charge to review estate planning documents. And if you've never done planning before, I want to encourage you to just relax and think in terms of kind of feeling out a relationship where you see if you're comfortable to enter into the kind of partnership arrangement where we want to create that atmosphere where you can think and you can consider all the issues and allow yourself to be educated and make an informed decision about what you want to do with your planning. We don't charge for initial consultations for estate planning, and we don't charge to review documents. So I thank you, and I would appreciate any comments you may have or questions, but please give us your thoughts and comments on our evaluation. And I wish everyone a wonderful week, and I hope you stay safe and well, and be very cautious. Jeff, I'm going to turn it back over to you.
Well, thank you, Steve. I think we can give Steve a virtual hand for a job well done. Thank you very much, Steve. So send those questions in. We have an attentive and a large, but a quiet crowd here today so far, Steve, taking everything in. While you're sending your questions in, I want to let you know I'll be sending today's video out to you tomorrow when the link becomes available to me. So if you want to review it or send it out to any friends or family members that couldn't be here today, you're welcome to share that. Also, I'm going to be sending you some information about some other events that we have coming up, including estate planning for young families and young parents. We have our advisors forum for our financial advisor community coming up on the 27th. Also another special needs planning workshop on May 29th, and our popular quarterly estate and trust administration event on June 10th. So be on the lookout for links for those, and we hope to see you on those events as well. So
Jeff, I have a quick question. For anyone who wants to view this again, we had some feedback a week or so ago at a webinar we did where someone had to leave during the webinar and wanted to know if they could see it again. Is this recorded, Jeff, and can we send it out to anyone who's interested?
Yes, Steve, this is recorded, and I'll be sending the link out to everybody, and we will have it up on our website as well, in our video links as well.
Very good.
Any questions by anybody? Let's see here. We have a quiet crowd, Steve.
Well, you know what, Jeff? The sun did go in, so maybe that has something to do with it, but
I think so.
it'll come back out.
Okay, well, if you have any questions that come to your mind, as always, you have Steve's email right there, Steve at elvilleassociates.com. I, as Community Relations Director, can't give legal advice, but you can certainly use me as a liaison to Steve, Jeff at elvilleassociates.com. Feel free to ask me any questions or anything related to the firm, and I'm happy to be a resource to you as well. Okay. Well, thank you for being here today. We look forward to seeing you again, and be safe and well.
Thank you.